is a day given in the notice for termination. So let's say the notice says, I will terminate in 60 days. That's fine. You can set a date. Stop calling me. Back, right? You can set a date, say 60 days in the future. That's fine. There he is. I'm giving you credit. You're not even here. I'll start over. Right. Anyway, explain to him later. Okay. What happened? The second paragraph, though, is one that's actually relevant. It says you can terminate it on, read it, 1 month after the day. What that means is do not count the day. So basically, everything I told you last class, we have to back up a day. Oh, clean up your notes. But Ben, you're right, or at least your question was right. So I haven't had that question before, so I've been screening this up for some time, I think. It's in none of the property case books. I checked 3 property case books. None of them had this fact in there. I checked 2 treatises. None of them had it in there. I asked another professor on my floor. Didn't know. So anyway, so I feel somewhat bad, but not totally terrible. But anyway, thank you. And I think Alex and someone else get credit too. Will, yeah, you get credit too. So if you, what?
So when you count the 30 days, like the 30th day is not the end of termination.
I'm going to walk through the examples from last class. I'm going to have to change some things to your notes, and I apologize. And I don't like doing this, but it happens every now and then. So we screw up, and then we have to sort of confess error as we say in the course. Anyway, so thank you, sir. All right, so everyone see this is section 90. You don't need to remember, but it's 91.001 B2. Anyway, so now it's in your knowledge. You have that information. All right. So what I want to do now is actually walk through the examples from last class. Most of them were correct. Just a couple of them, the ones I highlighted in yellow, I have to clean up. Right. So let's go to example 5A. This is the same one from last class. And also I updated the case summary folder, the lesson plan on leaseholds. So if you just pull that up, I actually highlighted in yellow all the answers that are different. So that's ones you'll have to work on. All right, we're talking. Yes, Amar. I don't. I'm sorry. Thank you for reminding me. It should be up now. Okay. All right. So let's take a look at example 5A, and I'll spare you the recitation on this one because it was my screw up. 5A says, from landlord to tenant for year to year, starting on January 1st of 2030. Okay, so we have a periodic tenancy. Okay. It says on June 30th of 2030, the tenant provides the landlord with notice to vacate. This previously said this previously said July 1st. So I was counting July 1st. I cannot count July 1st, so I actually changed the question. If you look at your notes from last class, example 5A said July 1st. I've now changed that to June 30th. Everyone see what I did? I moved it 1 day back. And the reason why I did that is we do not count July 1st as part of the time period. Everyone understand what I just said? All right. So here we have now June 30th as the last day of June. June has 30 days. So what does this mean? There's adequate notice given. You have 6 full calendar months. You have all of July, all of August, all of September, all of October, all of November, all of December. 6 full calendar months. And because there are 6 full calendar months with this periodic tenancy, you have enough notice. With a year-to-year lease, at common law, you must give half the period, which is 6 full calendar months. And again, you must give the notice on the 30th of June. You can't do July 1st. That doesn't count. Right? Everyone see that? Again, I apologize profusely for this, and I'm mad at myself for it, but you live and learn. Okay. The reason why is I check all the property books. They just say, oh yeah, 6 months, 30 days. They don't actually say 30 days from when. I checked every book. None of them say it. It's actually, I bet there's millions of properties who have no idea when to start counting. And I'm just actually so mad at myself. I've never actually, anyway. So I hold you guys to high standards. I held myself to even a higher standard. So if you can tell, I'm not happy with myself. All right, let's do 5B now. Okay. 5B says from landlord to tenant for year to year, starting on January 1st. So same as before. But here, instead of starting on June 30th, now we start July 1st. Or we start July 1st of the first day of the month. We give notice to vacate. Here, there's not sufficient notice. Right? There's not sufficient notice. Because you save it on July 1st, you do not have 6 full calendar months. You don't count July. You do August, September, October, November, December, January. And because you go into the next year, it renews for an entire cycle. So an entire another year is added to the lease. This lease will now end December 31st of 2031. Again, in 5B, because you put the notice in 1 day late, it expires December 31st of 2031. An entire new year is added. So see the difference the year makes. And let me make this point a little differently. If I screw this up and other property professors don't know this, how the hell are tenants supposed to know this? Right? I just want to make this point kind of just general. Like, I mean, I was actually looking up and Googling and finding the most useful sites were sites for tenant rights sites. In other words, sites explaining how do you actually do landlord-tenant law. Those are the most useful sites. Every property book just ignored this issue. I'm so annoyed. I'm going to actually send a note to the publisher and say, actually put this point in. It's such a simple idea. If you screw by 1 day, you're kicked out for another year, Emily. So I'm sorry, but we'll make this better for next year. I know it doesn't help you, but we'll your future students who are currently still in college, maybe they'll benefit from this. All right, now let's do example number 6A. We turn now to the periodic tenancy, the month-to-month lease. And 6A says from landlord to tenant or month to month, starting on January 1st of 2030. Then it says on June 30th of 2030, the tenant provides a landlord with notice to vacate. If you look at your notes from last class, this has changed. It was July 1st. I pushed it back 1 day to make the question work. Okay, here, because notice was given on June 30th, you have an entire period, entire month of notice, the entire month of July, right? All of July is covered. Therefore, the lease terminates on July 31st. The tenant does not have to pay rent in August. Just pay rent in July 31st. The lease ends July 31st, and then he can move out. Everyone gets 6A. Okay. All right, let's do 6B. Okay, 6B says from landlord to tenant for month to month, starting on January 1st, on July 1st of 2030, the tenant provides notice. July 1st does not count. You do not count July 1st, so therefore you burn the month, right? You do not have a full period. So the first full month would actually be August, and then the lease ends August 31st, right? September, he's out, doesn't pay September rent, but he's required to pay the August rent. So again, here you see the difference of 1 day. 1 day can mean you're on the hook for another month of rent altogether. Everyone with me? Now I think things are clear. Yeah, it's the worst feeling in the world when you realize in the middle of the class, and then you can't give it the time you need to actually think. So that's why I said I'll come back on Thursday. So, and actually, my second class got it right. I figured it out over lunch break, so then they had the benefit. So unfortunately, sorry, section B. Unfortunate, but that's how the schedule works. All right, 7. Okay, so we were previously doing the common law, right? Now we do the modern approach. Under the modern approach, the answer is not 1 full calendar month. Under the modern approach, the answer is 30 days. 30 days. And I checked this. You count weekends, you count holidays. In some instances, like with court filing deadlines, you may not count weekends. You may not count legal holidays. So I know this sounds really stupid, just be very attentive to your rules. In some other contexts, you do count the day of filing, which is why I got tripped up. In CivPro, you can count the day of filing for your statute of limitations, right? But in this landlord-tenant, you don't, which is why I got screwed up. All right, so let's read 7A. This is modern. From landlord to tenant for month to month, starting on January 1st. Okay, then I tell you on July 2nd, 2030. On July 2nd, the tenant provides a landlord with notice to vacate. I'm telling you, it follows the modern rule. Okay, so I have here a calendar. Don't laugh. Look, I'm being completely honest with you guys. I spent this. I was doing this all lunch. I was just counting over and over again, make sure it's right. I hope I don't screw this up now. All right. So you give notice on July 2nd, and this is a different year, but it doesn't really matter what year. It's the same months every year, right? So you give notice on July 2nd, right? Do not count July 2nd. So we start with the 3rd. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29. What did you say yesterday? She was right. August 1st. The lease terminates on August 1st. That's the last day of the lease. August 2nd, you got to be out. Right? So you count 30 days and you do not count the day in which notice was given, which was the 2nd. Don't count that day. That's where I screwed up. Yes. I mean, that simple error infects 6 questions. So you do not count the 2nd because that's the day that notice was given. In other contexts, you do count it. So for service of process, in some cases, you count the day in which service was granted, which is, so just be careful you're counting correctly. Okay? So the rent would only be paid on August 1st. You pay 1 day of rent that month, and the rest of the rent you're free. So the modern rule is a lot easier. You can give notice on the 2nd of the month, the 3rd of the month, whenever, and they prorate the rent for the number of days that you're covered. Okay, everybody with me? Let's do what's the next one? 8A. Okay. 8A. Okay, this is a periodic tenancy. I'm sorry, this is a tenancy at will. Right? With a tenancy at will, you need 30 days notice. Not a calendar month, 30 days notice. All right, so 8A says landlord to tenant at will starting on January 1st, 2030. On July 1st, 2030, the tenant provides the landlord with notice to vacate. Okay, so they gave notice on July 1st. Okay, so let's count. Right? Notice given July 1st. Ready? We don't count the first, we start here. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. So in this one, the tenancy ends on the 31st of July. If you want to print out a calendar for your notes, do that. That's entirely fine. Maybe I should have done it before class yesterday, but it's there. Okay. Questions in 8A. Yeah. There's not. I don't think there's a modern versus common law rule distinction there. I think that's the rule. And if there is, the book didn't include it, so I'm going to leave you alone about it. Seriously, I'm going to write a very nasty note to the editor after saying I can't believe you omitted this fact because I checked. I'm not kidding. 3 textbooks, and not a single one of them said whether you count the day in which notice was given. Not one of them. I couldn't believe it. I just had this brain warp. Yeah.
For exam purposes,
Modern versus common? Yeah, I'll tell you what yours think. Yeah, no, I will always tell you whether you're following the modern rule or the common law rule. But I'm going to caveat this. With marital property, it gets tricky. I might say you are in a common law jurisdiction with a community marital property system. And that just screws people up when I say that. But just you have to know which is which. And I can even say you are in a community property jurisdiction that follows modern rules, like California and not Texas. So just I want to make sure, Shadi, I'm doing your question carefully. All right, let me do last one, 8B, and maybe we'll get back on track for today. Okay. So 8B says, from landlord to tenant at will, starting on January 1st of 2030. On July 2nd, 2030, the landlord provides notice. Okay, so we're back on July 2nd. What do? We count 30 days. Okay, so we start with July 2nd. Oops, wrong tab. I'm sorry. July 2nd, notice given. We start 30 days over here. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29. August 1st. That's the same as before. So then you have 30 days. The tenancy will terminate August 1st, and he has to leave by 11:59 on August 1st. He can't be there at midnight. Okay, I think I cleaned everything up. Are there questions upon that? I apologize to Ben and Alex and a few other people who were like, "You're wrong." No, they were actually respectful. Always challenge authority, and I don't mean that. I mean that sincerely. Like, your boss is gonna make a mistake, and it's a skill to know how to present that in a way that doesn't make you look like a jerk, but can like tell them like, hey, on the side, like that might be wrong. Just be sure you're right. But if you, in other words, I encourage you to do it, but make sure you're lined up, because if you don't, then it looks bad. But always be willing. And courts screw stuff up also. So if you're ever clerking, the most dreaded motion you'll ever get is the motion for reconsideration. Right? What's that? So let's say a judge issues an opinion, right? And there's an error in it. Of course, the party can do an appeal to the Court of Appeals, right? You're allowed to do that. But that might be a waste of time because the judge made a mistake he didn't realize. So you'll sometimes see as parties file a motion for reconsideration saying, Judge, take a look at page 15, paragraph 5. You got a fact wrong. And because you got this fact objectively wrong, the elements of the test should go the other way, right? Or, Judge, you cited this case and that case has been overruled. Or you cited this statute that's been repealed, or you cited this precedent and you cited the dissent and the majority. I mean, things can happen. And when you get this motion for consideration, it's like, oh crap. And often the other side will say, yeah, they're right. Right. They're like, yeah, no, that they can't dispute. Like, there's a fact and the judge messed it up, because people are fallible. Right. When I was clerking, there was one case, I won't even tell you what it was about, but I made a mistake, and it wasn't a terribly huge mistake, but I cited something that was in the motion to dismiss that was in the complaint, right? And if you don't have something in the complaint, it doesn't exist in the case. So they put a fact in to dismiss that was not in the complaint, and I screwed it up, and the judge didn't catch it. And then like 24 hours later, we got this motion for reconsideration saying, Your Honor, you screwed up. I'm like, oh. And we reissued the opinion, and we revised it accordingly. And there was no need to file an appeal, right? The other side kind of half argues like, well, we like his opinion. It's and it didn't change the outcome. The outcome was the same, right? It just, there was one specific fact that was not in it. So we all make mistakes, and just have to learn how to handle them properly. I think you did it well yesterday. So I'm done apologizing. I want to move on. Any questions on the calendar? I guess this is my payback for complaining people on the months of the year. Anyway, so maybe that's my comeuppance. I don't know. Karma works in funny ways when you're a professor. It'll come back to bite me next year somehow, I'm sure. Okay. Questions on the calendar stuff? All right. A little bit behind track, but we'll pick up. All right, let's do some questions. We'll get to the cases. All right. I think the clicker should be working. Question number 1A. Multiple choice, please. I know it's not working yet. Here it is. Okay. Is that working? Yeah. Okay. So question 1A. Blackacre from lessor to lessee for 1 year beginning October 1st into A and his heirs. What interest does A have here? Okay, who's up next? Okay, Lisa, go ahead. All right, what's your answer here? Why do you say B? What a perfect answer. Thank you. Bravo. Right? Or bravo. Right? It's a future interest following a natural termination. That's a term of years. Goes to a third party. That's a remainder. Good. Oh, 80%. That's really good. Sounds good. None of the above. Not sure about that. Uh, anyone? None of the above. What were we thinking? I'm curious. No one. Okay, that's fine. I don't look. Actually, I don't look up afterwards who gets what, so it doesn't really matter. Maybe I should, but I don't. It's just only so many things you can do in life. Um, B is correct. It's a remainder here. And let's just get our terminology straight, right? No, Zach, right? No, no. Oh, that's pink, orange highlighting. My goodness, I can't see that. I know, but black. I need ink. Bailey, I'm sorry. Yeah, it's just the pink. Actually, see that pink I can read, but that orange is really faint. I just don't know. Okay, Bailey, go ahead. Um, what is it? Who's the lessor and who's the lessee? What are those terms? Just so we get a terminology straightened.
The lessor is the one that is in the lease.
Okay, and who's the lessee?
Person that's paying and so.
Okay, all right, that's correct. Now the trick I told you, which you're welcome to use or not, is you look at the suffix or and ee, right? EE is one who receives. So the lessee receives the lease. OR is gives. Lessor is one who gives the lease. Okay? Okay, good. Thank you so much for that, Bailey. All right, let's look at 1B, and this will be for Zach in about 30 seconds or so. Blackacre from lessor to lessee for 1 year, beginning October 1st. What interest does the lessor have? All right. Okay, just another 5 seconds. All right. Help us out, Zach. What's your answer here? Okay, why do you say reversion? Correct. And what's the estate given here? What do you call the type of estate? Exactly. The present interest is term of years, and the future interest is reversion. That's absolutely. Oh, 98%. That's pretty damn good. Good job, everyone. Okay. All right. I like that. No one put C. No one put D for sure. That's also good. All right. Let's take a look. This will be for John. Question number 2. I'll read it. It says on October 1st, 2020, Larry leases Blackacres to Tom for 1 year, beginning October 1st. On September 30th, 2021, Tom moves out without giving notice to Larry. Was Tom required to give notice? Okay, and take some time. Put your answers in. Yes or no? Excuse me. Or you're all safe. There's plexiglass here. So, no? Too soon? I don't know. I don't know. I don't know anything anymore. Rice went back to masks, so what the hell do I know? What do I know? All right, John, help us out here. What's your answer? Okay, why do you say no?
For a term of years, it ends automatically.
Correct. He's correct. In number 2, this is a term of years lease. This ends automatically. No notice is required for a term of years lease. You can just leave on the day. The lease ends September 30th. You just walk out, and that's it. I can trip you up on the exam like this. You'll start counting on the calendar, all these crazy things. I was like, there's no notice required, right? So just be attentive of what kind of leasehold you have. All right. I'll see number 3 as we for Frank in a moment. Okay. Good. So far, so good in the questions. Oh, did they even check? 75-25. Okay. Not great, but good enough. Question 3A. It says, on October 1st of 2020, Larry leases Blackacre to Tom from year to year, beginning October 1st. On September 30th, 2021, Larry moves out without giving notice to Larry. I'm sorry, Tom moves out without giving notice to Larry. Oh, by the way, T, Tom for tenant, L, Larry for landlord. That's not very creative, but it helps remember who's who. Was Tom required to give notice? Yes or no? This is for Frank in a minute. Give me another 10 seconds. Okay, I'll stop it here. All right, Frank, what's your answer? Okay, why do you say yes? Okay, very good. Now it's a periodic tenancy. Okay, with a periodic tenancy, you must give notice 85%. Very good. Okay, so let's do question 3B, which is basically the same setup as 3A, but my question is different. It's at common law, when must notice be given? And now you can start counting. Okay. Again, this is a common law rule. At the common law, when must Larry give notice to Tom to vacate by December 30th of 2021? Let's wait for Chloe in a moment. All righty, Chloe, help us out here. What is your answer? Louder? March 31st. Why did you say March 31st? So let's count, right? What are the full 6 months, calendar months? If you give notice March 31st, what's the first calendar month you count? April, then May, then June. 6 full calendar months. When can you vacate then? Correct. She's right. It's B. Okay, very good. Okay, good. Oh, that's pretty good there. 85%. Good job. Right? So if you give notice March 31st, you start counting April 1st, right? We count the first day of the month. April 1st, May 1st, June 1st, July 1st, August 1st, September 1st. You get 6 full periods, and then you go on to vacate the end of September. Good job. Everyone get that one? All right, I think we're a little bit more calm than we were yesterday or on Tuesday. Okay. Now this is if I make some multiple choice, it's too easy, so I'll just do a short answer. If Tom fails to give timely notice, when will his lease terminate? And I don't care what format you put it in, just give me the right date. So in other words, let's say he doesn't give notice on March 1st, let's say he gives notice on April 1st, right? If he doesn't give timely notice, when will the lease terminate? Let's wait for Callie in a moment. Okay. All right, Callie, help us out, my friend. What do you have here? Correct, but I'm looking for a specific date. What date would it terminate on? Not October 31st. September what? September 30th? Is that your answer? You sure? All right. Oh, give it some more thought. What? Come on, Callie. Chloe. Callie. Sorry. Right. lease begin on? So what date will it terminate on? I'm not counting 365 days, my fingers. I don't have that many fingers. It'll take so long, right? But if well, there is no September 31st. What's the last? How many days in September? That's okay. Okay. The answer is September 30th of 2022. Okay. The answer is September 30th of 2022. And let me just sort of, yeah, I think a lot of you got this all right. Good. Yeah, those are all correct. If a lease begins October 1st and it's for a period of a year, it ends September 30th, right? It's a full calendar year. By failing to give timely notice, it kicks the next year. Okay. It's not October 1st because that will be a year and a day. It's just 1 year. Maybe a year and a day rule. Do they still teach that one with murder? If you shoot someone and they die or more than a year and a day later, it's not your murder. I vaguely remember that. Okay. September 30th. Everyone okay with that one? I think I have one more question, then we can move on to today's material. We'll finish, don't worry. We'll do some time. All right, question number. Oh, I have two more questions. I'm sorry, I lied. I might just do one of them. All right, let's just do question 4. Oh, we'll do question 5. We'll do question 5 as well later. Okay, let's do question 4. Multiple choice. Let's see for Elizabeth in a moment. Okay, in October 2020, Larry leases Blackacre to Tom for month to month. The rent is $100 per month. On June 15th, Tom notifies Larry that he will vacate on July 1st. Uh-oh. On July 1st, Tom vacates Blackacre and stops paying the rent. On October 1st, Larry leases Blackacre to Sally for $100 a month. Larry sues Tom for the unpaid rent from July, August, and September. Okay. At common law, how much does Tom owe Larry? Okay. All right, another 5 seconds. It's a little trickier. I'll stop it here. All right, Elizabeth, let me ask you a question, please. Did he pay rent on July 1st? Yes. Did he pay his July rent? No. Did not pay July rent. Did he pay his August rent? Did not pay August rent. Did he pay his September rent? Okay. Can the landlord sue for all 3 of those months? So what'd you put here? Okay, so let's just think about this for a second, right? The landlord's getting rent from Sally in October. Okay. Is he getting rent from Sally in September? Okay. When did this lease terminate, Elizabeth? Well, he gave notice. When did he give notice to vacate? Hold on. I think you gave me the right answer. He gave notice on June 15th, right? Is that sufficient notice to leave on July 1st? What is the earliest date that he could vacate with that notice? Well, you need, right? You need how much time? 30 days. So a common law, what's the one full calendar month that's covered? July 31st, right? So what's the date the lease ends? July 31st, okay? He can't leave July 1st because you need one full calendar month. By giving notice on June 15th, you need a full calendar month, which is the month of July. July 31st, what happens? So how much rent is actually owed? Yeah, 100. That's what we got. Okay. Yeah, that's majority. Okay. So you have to keep two things in mind here, right? First, when you give notice in the middle of a month, it kicks the next month. There's a full calendar month, which is the month of July. And July 31st, he will no obligation to pay rent August 1st. Okay. But also keep in mind the unjust enrichment argument. If the landlord's collecting rent from a new tenant, he can't go back and sue the old tenant for that same period, right? It's an unjust enrichment. You can't double dip. You can't get two rents for the same apartment. You're not allowed to do that. So in this one, he can only sue for the July rent. He can't sue for the August rent. He can't sue September rent. All right. Good. All right. I think we got this more or less straightened. All right. Last question. This is actually bridging to the next topic. Okay. This is multiple choice. This will be for Crespin in a moment. A lot of questions. I haven't done questions in a while. I'm very questiony today. Question 5. Question 5 says, O conveys Blackacre to A and fee simple. A enters Blackacre and finds that property is condemned and he cannot live there. At common law, A can rescind the purchase. True or false? Okay. Crespin, what's your answer here, sir? Okay, why do you say false?
He had the person in the property knowledge. Not up to the person who already invaded and heard of the property.
Well, what's the difference, Crespin, between legal possession and actual possession?
Actual possession was he being in his property physically.
Can you be on property that's condemned by the state? No. You know, they put like the police tape, right? They put a barrier. You can't even walk in. Is there actual possession in this case, Crespin?
No.
Is there legal possession? And what does the common law rule require? Good, that's correct. So the answer here is false. They cannot rescind the contract. Okay, about 7%, that's good. You want to say yes because it seems unfair, but the answer is actually no at common law. Right, so this is the segue to the first case, which we're now 40 minutes in, but we'll get to. Hannon versus Dush from Virginia. And this case illustrates there's a difference in actual possession and legal possession, right? So what are the facts here, James?
Hannon entered into a lease with the landlord
Dush is good. The other one's worse.
and
There it is.
supposed to start
I experienced in this one. Yeah, go ahead. Yeah, go ahead.
It started January 1st, and then the day it was supposed to start, there was a holdover there,
Yeah.
and he took a report about the suit.
So let me ask you a question, James. Let's say you sign up for an apartment to begin July 1st. You walk in and the holdover is still there. Who do you call? The cops or the landlord?
Landlord.
Landlord, right? People call the landlord. But under the common law, can you call the landlord? Who do you call? You call the cops. Right. So here what happened was a guy signed a long-term lease, was it 15 years or something, right? He shows up and there's some guy still holding over. And apparently the landlord knew about this, but didn't take action to expel or to evict the holdover tenant. For all we know, he was collecting double rent, right? We don't know all the details here. And there were two rules, right? There's a common law rule, which is basically I won't say common law. There's the English rule and the American rule, right? Max, help us out here. What's the difference between the American rule and the English rule here? Good. What's an implied covenant, Max? Help us out. What does that phrase mean, implied?
So it's not expressed within the contract, I think.
Yeah. So who implies it?
It would be started, I think, at the least.
No, but who's doing the implication? It's not the parties.
It's the land.
No, it's not the landlord. Landlord doesn't want this term. Oh, can he do it by himself? What does it mean to have an implied? This is actually a very good question, Max. What does it mean to have an implied term, like an implied warranty of habitability or merchantability? What does it mean to have an implied warranty?
It's the opposite of express.
Correct, right? Express means the parties reach that term. So who's doing the implication? Who's implying it? Yeah.
No.
Oh, someone. Kylie? The law. Who is the law? Am I the law? Am I the state? Who's the law? Court. Thank you. Very good. The court, right? When you have an implied warranty, whether it's of merchantability or whatever else you may have studied, you have the implied warranty of habitability for landlord properties. The courts are doing the implying. The court are doing the implication, right? So in this case, the parties did not reach an express agreement saying, I guarantee you actual possession. That was not, they could have, but they didn't. I mean, who would think to even do that, right? Don't you assume when you have a lease that you're getting actual possession? Bad assumptions. Don't assume. You know what happens when you assume, right? You know this or no? You make an ass out of you and me. You've seen this, right? It's actually from the Odd Couple from other places, but anyway. When you assume, you're screwed. So the parties here could have made an express covenant. They didn't. Under the English rule, the courts will imply a covenant or a warranty. Covenant's just a promise. They will imply a covenant of actual possession. That's the common. I'm sorry. That's the I shouldn't say common. It's confusing. That's the English rule here. I'll say English and American, make it easier for you. What about the American rule, Camille? What's the American rule?
What's the tenant in legal possession?
No, not legal. The other one. Correct. Right? Thank you, Camille. With the American rule, the court will not imply a covenant for actual possession. Right? The court will not imply a covenant for actual possession. There will only be a covenant if the parties expressly reach that term. So under the American rule, Camille, finish it up. And what happens to the tenant here? Does he win or lose? He loses. Does he have any right to have actual possession to the property? No. Right? So Julius, what must the tenant actually do here? He shows up, he sees this guy sitting in his house. Instead of suing the landlord, what must he do? Not the landlord. Who's in the house? The holdover. Yeah. I know what you meant, right? The new tenant must come in and basically sue to eject the holdover. Right? Now, I mean, this rule is not ideal because if you think about it, who is in the best position to know about a holdover tenant? It's the landlord, right? He knows he's there. He maybe isn't collecting rent from him. The English rule at least makes some sense, but the burden on the person with most knowledge, right? He's in the best position to expel the holdover. Because you imagine, right? Imagine like you show up with your moving truck, you're ready to move in, and some guy's there. You had no idea. You don't know what's going on. The landlord probably knew though. So the American rule is criticized, of course. For those who care, Texas, I think, follows the American rule. So America, right? So sorry. It's old school. So if you don't have actual possession, too bad. As long as you have legal possession, that's all that's actually required to be delivered. Right? As a practical matter, though, if you look at your lease, go home and read it later. I'm like 99% sure of the term saying the landlord guarantees actual possession. I might say entry or access. There'll be some word, right? But there'll be some, and go check it. Maybe I'm wrong, right? But go read your lease, and there'll be some language saying that on the date that the lease begins, there'll be some actual possession or a right of entry or right of access, or something else. Because I can't imagine a modern lease doesn't have that term. Zach. Right. I mean, the American rule is the common law rule, which is the opposite of what you think. The English rule is kind of the modern rule, which is why I'm trying to avoid saying that. But yeah, so again, the American rule will be the common law rule, but the English rule is the modern approach, if that's how you want to think of it. But I would just use American versus English, and that's the language used in the book. It gets tricky with all these common law American distinctions. You sort of lose track. But again, yeah, check your leases. But I mean, you can imagine a situation where a tenant refuses to move out and they have to evict him quickly. That's why I think most apartments nowadays have like a 2-week window between the move-out date and the move-in date, so that to make sure they can handle any sort of problems. That the guy holds over, they can get rid of him. I don't know. All right. So any questions in the first case, Hannon versus Dush? Okay. Yeah, I think it's a pretty simple case, not very complicated. The second case is a little bit more complicated. So always gives students a little trips people up. Let's talk about subleases versus assignments. Subleases versus assignments. Diddy, help us out. What is a sublease? Correct. Good. Very good. Right. A sublease is when you transfer part of a leasehold to someone else, but not the entire bundle of sticks, right? The tenant gives some interest to a third party, but he keeps some for himself, right? It's Maria, right? Maria, what is an assignment? No. Diddy said that the sublease is part of the bundle of sticks. What's the assignment? Okay, very good. The assignment is when the tenant conveys the entire bundle of sticks. Everything is given to someone else. Okay? The tenant retains no interest for himself. Right? Now, a lot of you have probably done a sublease before. What you probably didn't realize is that you might still be on the hook for the rent. Did anyone realize that when you did subleases till now? Maybe you did. I don't know. But a lot of people think, oh yeah, sublease, peace, I'm out, right? It's not my problem. But if the person you give the sublease to screws up and doesn't pay his rent, guess what? Landlord's coming after you. So with the sublease, the original tenant is still on the hook for rent. With an assignment, the original tenant, he's out, right? He's done. He's not involved in the contract at all. All right. Everyone with me? All right, let's do the second case. The second case is admittedly complex, the Ernst versus Condit case. Brock, okay. Just start us off with the facts, with at least the initial lease, the first lease in this case. Okay. He didn't operate for a year. It's actually a much shorter period. Yeah. I mean, he barely ran it for a month. All right, go on. Okay. All right. So let me just pause you there. Okay. So we have a piece of property. Let's just call it Blackacre. Okay. Everything's Blackacre in this class. Ernst leases Blackacre to Rogers for a period of about a year. And he builds this amazing go-kart business that would not succeed. But, this is a classic tale, right? Only lasted for a few months, whatever, right? He puts on an asphalt track. He builds fences. He puts in lighting. And they set the rent at $350 per month or 15% of sales, whichever is greater. So they were probably hoping that this is a successful business, and then 15% of the revenue from the go to the landlord. The lease had a term saying that any sublease or assignment must get the landlord written. It's common, right? This is almost always going to be the case. Rogers runs a business for a month, and then, like Brock told us, he sold it off to Condit after a month. And Ernst allowed Condit to take over the lease. All right, so by my count, there are 8 elements of this lease. There are 8 relevant terms. The first is they extend the lease by 1 year. Right, so the initial lease was from 1960 to 61. Now the lease runs through 62. Right, so expanded the lease. Second, the lease says that Ernst consented to, quote, subletting the property. The lease says subletting. Huh. Okay. Third, Rogers agreed to sublet the premise to Condit. Again, the word sublet's in there. Okay. Fourth, Condit accepted the subletting of the premise. All right, so we have this phrase, subletting, over and over again. So one might think by reading this that it's a sublease rather than an assignment. All right. But then we get to, I think, the more important parts. Roger promises to remain liable for the performance of a lease. And then it says Roger remains liable for performance of all terms and conditions of the lease. So Tyler, if Roger is agreeing to remain liable for the terms of this agreement, doesn't that sound kind of like a sublease? Why?
Because he's passing on liability to somebody else, but myself, my apartment, I'm still responsible and make sure.
Yeah. Yeah, so I mean, this is a case that's kind of weird, right? The word sublease appears over and over again. And then Rogers, the original tenant, is saying, yeah, I agree to be liable if something happens. Okay. And then the says all the other terms from the original 1960 lease remain in full force. And Condit agrees to perform the lease. Huh. So I don't know. What do I know, right? What do I know about Tennessee law? Apparently nothing, right? So I can't see it blocked yet. Yeah, Kyle. So then what happens after the second lease is drawn up? How does this go-kart business go, as it were? Yeah. Okay, so his business apparently fails, right? The go-kart business sputters out. And then he stops paying. So yeah, you got that. And then he stopped paying rent. Thank you. Thank you. Please clap, right? And he stops paying rent. Now, Kyle, why do you think he stopped paying rent? I mean, do you think he was worried about getting sued? What did he think was going to happen?
That sublease that would be responsible for it.
Right. But who's the first person to get sued, though? Do you usually sue the sublessee or the original tenant? Yeah. So I mean, technically, you can go after the sublessee, but I think the better answer is who has deeper pockets. I mean, that's usually what happens. And this guy just went, his business just failed, so he probably doesn't have money. Just probably somebody judgment proof, as you might say. So Condit's, I'm sorry. So Condit's like, I'm not paying anything. Go after Rogers. Okay. Now Rogers isn't in this case, right? He's not really in the case. So here's the argument, right? If this is a sublease, Rogers is still liable. If this is an assignment, Rogers is out of the picture, right? If it's a sublease, Rogers is still in the picture. If it's an assignment, Rogers is out of the picture, and everything goes to Condit, and they can go after Condit's assets. Then the question becomes, how do you decide what kind of lease is this? Is it a sublease? Or is this an assignment? Right? Now, there's some arguments that this is a sublease. Okay? So first, it extended the lease by 2 years. Okay? Second, it uses the word sublease over and over and over again. Third, Roger says, I'm going to remain liable, right? He puts his name right there. And also, Rogers had a reversionary interest to re-enter. So Condit argues that this is a sublease because Roger remains liable for the rent. And in fact, Condit says Rogers is primarily liable, right? Go to Rogers first. Okay. John, what did the court hold here?
That under either the common law or the one rule,
How? How do you possibly reach that result, John? I mean, every time I teach this case, huh? Right? How did they get to that result? So do they care what words the parties used? I'm sorry, I'll say it again. Does the court care what words were used by the parties? Is that usual to see that in an opinion like that? When you guys took contracts, say we don't care what they wrote, we care what they intended. Is that the opposite what you usually do? Right. So this is weird. Right. Again, I don't know that this I shouldn't say that. What do I know about Tennessee law? But this just seems like a wrong opinion. This reminds me a bit of the New York case with Garner versus Garish, right? Where they have the tenants, the life estate determinable, whatever the hell they called it, right? But they said, well, we're not going to really look at the words they chose. We're going to just go by their intentions. Oh, so that's something like this, right? So it seems here the court says the intent was not to do a sublease, but the intent was to do a assignment. And they put a lot of weight in the bundle of sticks, right? Margot, help us out here. Did Rogers keep any sticks in the bundle, or did he give the entire bundle away to Condit? Everything. That's right. Thank you. The court says here, I'll read it to you, that an instrument that transfers the entire estate for the entire remainder of the term is an assignment, right? There was no reversionary interest back to every day the lease was transferred out to Condit. And in fact, they added time. There was every day plus another year. So under this common law rule, we have the parties' intentions, right? 100% of the time was conveyed. Parties' intentions here don't matter. That's a common law rule. But under the modern rule, we look at intentions, which leads to the same result. And they said under the parties' intentions, they intended to convey the entire interest. Rogers reserved nothing for himself. Rogers reserved no reversionary interest. Okay. Condit would have the property for the entire term. For the performance lease, it says Roger remains liable. It says this over and over again. How does the court deal with those facts? That's okay. How do you, it says it here, remain liable. How do you deal with those facts?
They don't outweigh.
Say it again?
They don't outweigh
Okay.
everything else.
Yeah, I think that's right. What do you guys do? Pictures, okay. But whatever. Right. Yeah, Shadi's right. I think the court acknowledges that this I think the court acknowledges that that language helps the argument that there's a sublease, but it doesn't outweigh the rest of the evidence. I think that's actually a good answer, right? Better than what I had in mind, right? That if you look at all the factors sort of considered, the weight of the evidence supports an assignment rather than a sublease. And then the court, this is my favorite part. The court says it is unsound to focus on the words they chose. Unsound to focus on the words they chose. My goodness. I mean, just that strikes me as appalling, right? But maybe it's not so crazy, right? These were not sophisticated people, right? They weren't lawyers. I don't think they were. Most people use the word sublease and assignment interchangeably, right? If I'd asked you last week the difference between a sublease and assignment, you would know. So maybe it's reasonable for the court to say, look, these are not lawyers. We shouldn't hold them to the words, which is the exact opposite of how everything else works, right? If you sign a contract and you're not a lawyer, guess what? Your words are going to bind you. So I don't know why in this context of the lease and the assignment, the usual rules of interpretation sort of go out the window, but I get animated at this case. I'm sorry. But just, I don't like it. I think this is a sublease 100 times over. Easy, not, easy case, but what do I know? I can't even count 30 days, so don't ask me. All right. Okay, so, oh yeah.
So I just want to tie it back to
Don't say calendar, please. No,
was that?
don't say the calendar.
No, it's not that. So, but Ernst have a life estate for the duration of the lease, and then once the assignment is over, he then has.
Well, why life estate? The duration of the lease is about 2 years.
Yeah.
So why life estate?
Well, because he's not giving a fee simple. He's only giving.
Well, you talking about the landlord?
Yeah, the landlord.
Do you mean a reversion?
Like, if a landlord gives a lease, does he still has the life estate, correct?
Well, why? Well, I don't life estate. I don't understand your question.
I was just tying it back to.
No, but if the landlord starts with a fee simple, right, and you give a 2-year lease out to the tenant, the landlord keeps reversion for himself.
So he has no present interest.
None.
The lease is over.
No, he has he has reversion, future interest.
And then the reversion is fee simple.
Correct.
Okay.
Right. I mean, and technically, this is why I don't want to answer your question carefully. The landlord can re-enter to do stuff, right? If there's a breach or there's some damage. So it's not true to say he has no present interest, but he doesn't have present interest, right? It's just like in extreme circumstances. Like, your landlord can enter your apartment for maintenance, these various things. There's some type of present interest, but it's not the usual kind you think of. But it's a future interest reversion. Okay. Yes, Max, go ahead.
Yes.
Sublease or assignment, regular language within the lease is not relevant.
In this jurisdiction, at least, that's correct, right? I mean, what this court says is we don't really care what language they use because we think they intended to assign the entire bundle of sticks, and therefore we don't look at the language.
Okay, so that's not how we should assess it.
I don't know. I hate answering that question because I'm not sure. But if I don't know, I'm not sure. This is the rule here, at least, and at least the common law rule. That part is if you convey the entire interest, every day of it, that's gonna be an assignment. That rule, at least, you can follow pretty clearly. The modern rule, I'm not sure what even it is. Yeah, it's hard for me to answer your question, Max. I'm really not trying to dodge it because I'd have to actually write a sample lease, and then you'd have to sort of wrestle with it. So you could use this case or not. No, I think that'd be the answer. Shadi, is that your hand up?
I'm gonna say kind of like the oral evidence.
Oh God, don't remind me of that. Yeah. No, I'm sorry, that was me. Did I say battle the forms? Or do I give was it 2207? Do I make your head hurt? Yeah, I'm sorry. Yeah, I mean, look, once you get to interpreting a legal document and the court says we look not at the words chosen with the intentions, it's a free for all. It's whatever the hell you want it to be. It's a Rorschach test. You like Rorschach test? Yeah. You know, the ink blot, right? You said that butterfly, or is that, what is that? I would never give Lawson a Rorschach test. I'd be disturbed to see the results. Just because you guys are twisted, right? Well, we are. We're here for a reason, right? A life estate. I see a calendar with 32 days, right? All right. Anything else in this case? All right. So in the end, the court holds this as an assignment from the and because it's an assignment, conduct must pay the rent. And we have no idea if he actually ever paid. That we probably not. But it always amazes me, they appeal these cases all the way up to like $6,000 in rent. Is that even worth it? I mean, the attorney's fees have to be greater than the actual cost of the cost of the back rent. Lawyers always get paid. Remember that. You always get paid. That's not nice because you get paid up front, right? Unless you work on a contingency, you ask for retainer up front, and that's how you get paid. Okay. Questions on the second case? Okie doke. Let us go on to the let's go on to the third case. This case is actually complicated. The facts in this case are ugly. Kendall versus Pistana Incorporated. I'm warning you, it's a California case. You know what's going to happen, right? I don't lie. Am I right? It happens every case. California. Sarah, you're next. Hello. All right, Sarah, you want to give us a fact, or at least start the facts here are messy. So at least start the facts. I might interrupt you a few times. Yeah, good. Keep going.
So they lease space.
Okay, let's use names because the names do matter here. So the city owns this airport. It's in San Jose. It's in the Bay Area, near San Francisco. Who did the city initially lease the hangar to?
Not the defendants here, it's someone else who ended up wanting.
And so, do you know their names?
Yeah, it's 3 different people.
Yeah. Well, no, it's a couple.
Oh,
Perlich. Okay, so first, again, there are going to be several transactions, at least 4 or 5 transactions. Let's go into it one at a time. So first, the city leases the hangar to the Perliches. Okay, the city leases the hangar to the Perliches. The city is the lessor, and the Perliches are the lessees. Okay. Okay, Christina. She's like, oh, I'm done. Right, Christina. So, what was the second transaction after the Perliches got it? What happened? Well, they leased it, or what'd they do? No, we're not there yet. The Perliches, what did the Perliches do? Correct, thank you. The Perliches sublease it to who? Bixler, correct. For how many years? Okay, good. So again, the city leases to Perlich. Perlich subleased to Bixler. All right, so let's get our terminology. The Perliches are the sublessors. Okay? The Perliches are the sublessors. And Bixler is the sublessee. Right? The Perliches are the sublessors, and Bixler is the sublessee. Everyone with me? Okay. And then Bixler will use it to maintain aircrafts. All right, Austin, if the Perlichers are the sublessors and Bixler's the sublessees, what future interest do the Perliches have?
They have.
Correct. It's reversion. Okay. The Perliches retain reversion. After 25 years, it goes back to the Perliches. So this is kind of weird, right? The city has reversion, and the Perliches have reversion. They both have reversion. Because after 25 years, it goes to the Perliches, and eventually the lease for the city ends. It goes back to the city. We don't know the length of the lease for the city. Maybe it's 50 years. We have no idea. Okay, thank you for awesome. All right, we're not done yet. Okay, now, Avani, what do the Perliches do with their reversion? Okay, correct. The Perliches assign their reversionary interest to Pestana. Isn't that weird? They're assigning their future interest. The Perliches cannot take away the present interest to Bixler, right? That's a sublease. But the Perliches can assign their future interest to Pestana. The Perliches are the assignors, and Pestana is the assignee. Okay? And Ivani, one follow-up question. When the Perliches assign their reversionary interest, do the Perliches keep any for themselves? Okay, they're out of the picture, right? Okay, so now, follow me here. Bixler is still the sublessee, but Pestana is a sublessor, right? Pestana is a sublessor, and Bixler's a sublessee. So effectively, think of it, that Pestana is over Bixler, right? After Pestana's sublease runs out, it goes to Bixler. I mean, damn, I said it wrong. After Bixler's sublessee runs out, it goes to Pestana. This is hard to keep in your head, right? The Perliches have no future interest. Pestana now has reversion. All right, with me so far? Now it gets even worse. Okay, Bixler sells his business to Kendall. 3 people, just call them Kendall, make it easier, right? Bixler sells his business to 3 people called Kendler. Here, Ryder.
So, but if you, so you have the original owner, right?
Who's the original owner? Okay, be more precise, my friend.
That's going to be.
Don't say original owner. You got to give me better than that. Well, the Perliches had the reversion, and the Perliches assigned their reversion to Pestana.
Yes. In that case, since they weren't the initial transferor, would that actually, the reversion turn into a remainder?
No, because they transferred the sub. It's a reversion. Yeah, I know what you're saying. Let me try this again. I'm gonna lose. I'm gonna lose people now, but I'll do it again. Right? The Perliches sublessed to Bixler, right? They were basically the sublessor. The reversion goes back to the sublessor. It's not just to the city; it's to the sublessor in that case. So Perlich had the reversion. Reversion went to Pestana. Okay. Now it gets worse. Bixler wants to sell his business to Kendall. Bixler wants to, ready for this? Bixler wants to assign his sublease to Kendall. What? Right? Bixler wants to assign his sublease to Kendall. How the hell do you assign a sublease? You can do it, right? Bixler wants to give this entire bundle 6. So everything Bixler has to Kendall. Okay. Brianne, can Bixler unilaterally assign his interest to Kendall? No. Why not? Okay, tell us, what's an approval clause? I think we got the 10 minutes. We got the facts. Not good. What's an approval clause? Good.
Well, I guess it's originally the
Pestana? Perlich. Does the approval clause, Brianne, say the criteria in which you could withhold consent? Does it say what kind of consent you could withhold? But does the lease itself say that there's an absolute right to withhold consent? Does the actual text of the lease explain what kind of what kind of power the landlord has. But does it say that in the contract, at least? No, you're right. It doesn't. Right. The lease does not say the landlord. I could say the landlord. Actually, the let's just call them Pestana, right? The lease does not say Pestana can withhold consent for any reason at all. Absolute. It just says Bixler must seek written consent, written approval from the landlord, right? Which is always what's there. The question is this: must the decision to withhold consent be reasonable, right? In the views of Pestana, it doesn't have to be reasonable. It can be for any reason or reason at all. Bixler and actually Kendall argue that there must be some reasonable objection. Okay. So, Rodney, let me ask you this question. At common law, could I'll say landlord, make it easier. Could the landlord have absolute power to withhold consent?
No, not a common law.
At common law?
At common law, no, but the current majority rule at the time this was decided, that there was, you could have as free alienation as you wanted.
Okay, so at least in California before this case,
Yes,
right?
you could do whatever you wanted.
Absolute consent. But we're in California, so what happens?
They kind of changed it to a minority.
Got to change the minority rule, right? It's like we realize only a couple states do this. Let's go with that direction, right? Okay, so Ben, why does the California court go with this minority rule?
I mean, I know they say that it needs to have a commercial reason for.
Right. Okay, so the court says, what is the minority rule? Let's do the first. What is the minority rule?
It's that where the lesser can only withhold consent if there's a reasonable objection to the assignment.
If there's a reasonable objection, what might a reasonable objection be? Okay, good. Thank you. The court goes with a minority rule. They get rid of the majority rule and they adopt the minority rule. And they say, for the landlord to withhold consent, the decision must be reasonable, right? Maybe the future tenant doesn't have enough money, right? Maybe they're running a business that might be in violation of the law, right? Maybe there's some good reason why you're withholding consent. But that's not what happened here, right? The reason why consent was withheld here was the landlord wanted more money, right? Pestana wanted to extract the higher rent. And the court says you cannot use your consent as leverage to jack up the rent. If you want higher rent, you should negotiate a better lease, right? You can't use this power of consent to extract a higher rent. Now, why do they adopt this minority rule? Fairness. It's always the F word, right? They think that this minority rule is more fair, right? They want to promote alienability of property. If there's a new business that comes in, they want to allow them to, assign the lease more freely. Okay. The court also says that the parties wanted to negotiate an absolute power clause. They could have negotiated it, right? Nothing prevented them from writing in the lease, the landlord has absolute power to withhold consent. They didn't. So in the absence of this absolute power clause, they will infer a reasonableness requirement and make it easier for there to be a transfer. Then they go to stare decisis, right? The idea that you stand by precedent, like, oh, what the hell, it's California. We don't care. Only slightly exaggerating. They say this rule is not universally held. There's a trend. Oh, there's always a trend. There's a trend to the minority rule, which should come as no surprise. So again, if you're a California lawyer, do you just anticipate they're going to change the law on you? Right? I mean, I don't want to belabor this point too much, but you guys are in law school. You're studying the law, right? You're going to be representing clients in a couple of years. And do you have to anticipate? It's like, well, client, this is the law today, but there's this bizarre minority rule. You got to probably follow that one also. Right? So if you were advising your client in the 1970s or 80s in California, and he says, can I withhold consent? Absolutely. Like, well, probably, but you're going to lose in the Supreme Court of the state. So, I mean, it actually makes it a hard job for the attorney when the common law is always changing. That's just sort of a rant, but it's something to keep in mind. Okay. All right. A note: the court only discusses commercial leases. It does not extend this rule to residential leases. I think the reason why is with a residential lease, the landlord may have a more severe interest in sort of scrutinizing who's living in this property. So imagine you have a couple units in your building, and the tenant says, "I want to give it to Joe Smith," and you don't know who Joe Smith is. You might want to withhold for non-commercial reasons. All right. All right. Any questions on Pistana? There was a dissent. I don't think it was in your book, but the dissent says follow the common law rule, follow the majority rule. If they want to have this sort of this reasonableness clause, they can negotiate for it. All right. I'm with the dissent, but what do I know? All right. Questions on Pistana? We finish on time. All right. Let me wrap up, and I've done the minute poll in a while. I'll turn it on. I've forgotten to do it recently. I apologize. Right. So from today's class, God willing, you know how to count 30 days. I hope I do, at least. The important sort of points to remember from today are the difference between legal possession and actual possession. With the American rule, there's only a requirement to give legal possession, but under the English rule, there's a requirement to give both actual and legal possession. Distinguishing subleases versus assignments. The easiest way to remember is with assignment, it's a full bundle of sticks. With a sublease, something less than a full bundle of sticks. Courts somewhat grapple with how to interpret leases where the language isn't clear. And this last case, it's California, so they make it easier to make subleases performed. Anything else? I will see you all on Tuesday. If you're celebrating a happy Passover, I will be. See you all next week. Thank you.